Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Somebody asks the question, is it possible for Amber Heard to have won this trial? And I'm going to answer that question in just a second. When we talk about is it possible, I think most people recognize anything is possible. But I do think it is possible, or would have been possible, for Ms. Heard to have won this trial. But to do that, you have to have a much different plaintiff and you have to have a much different approach at trial. So the first mistake Ms. Heard made, from my perspective, again, I'm not criticizing, I'm observing here. First mistake was filing a counterclaim for $100 million. She had absolutely no basis for the $100 million. It was just double what Mr. Depp had sued for. So at the outset, that tends to make her look petty and punitive, and I don't think it does her any good. The second thing is, in order to prevail here, all she had to do was make a showing that the statements that she made about being a survivor of domestic abuse and were true. Now, one of the things that I have always maintained is that a confused mind says no. It always says no. If somebody comes in and says, we want to do this, and there's this that's wrong with it, and there's this, and oh, by the way, what about that? And they go through 15 or 16 different options. At the end of it, you're like, what do they even want? I'm confused here. I don't understand what you really want. The answer is always going to be no. Whereas if you come into someone and say, okay, the air conditioner is broken. We can repair the air conditioner, or we can replace it with a new one. Which of those two options do you like? That is simple and clear, and for the most part, somebody's going to be able to choose between those two options. The more clear and the more simple the narrative is, the easier it is for a jury to look at it and say, okay, I can buy that. So instead of 6 or 7 different claims of abuse, if she had stuck to one version of and one version of domestic abuse, she would have been just fine. She could have come off as being completely reasonable and a victim. But that's not what she did. So, I want to try and illustrate this in a way that makes some sense. One of the issues that I thought was very important is you had to establish the physical abuse component. And she didn't have any real evidence of physical abuse other than her testimony. So, unfortunately, this is a situation, when I played baseball as a kid, I had coaches tell me, look, quit swinging for the fences, just meet the ball. All you have to do is meet the ball and you'll get on base. We want you on base. That's how you get ahead in baseball. You put a bunch of singles together and you score runs. That's what she needed to do. She needed to put together a bunch of singles and score runs, and instead, she kept swinging for the fences and she kept missing. If she'd come in and said, I don't have pictures of the abuse that I took. I don't have pictures of the bruises, because who wants that memory around? I should have done that, but I didn't. And no, I don't have medical records either, because none of this was the kind of stuff that involves fractures, but the part of me that was being fractured was my brain. I was suffering this sort of mental abuse because every time I turned around, I had to duck and cover. If she had done that, if she'd shown a little bit of humility, yes, I recognize I don't have these medical records, she would have had an opportunity to prevail on the defense of the claim, on the defense of the defamation claim. But unfortunately, she went and it's kind of like that song that says, heard it from a friend, who heard it from a friend, who heard it from another, and the tales grow taller on down the line. And that's what's happened. When she started telling these tales, they grew taller and taller and taller and taller. And that was a bad thing. You know, there had not been any claim prior to the trial that there was any kind of an abuse with a bottle. And I think we all know what I'm talking about. I'm not going to go into more detail about that. But I think it is very, very important that you separate out the claims and look at ways that you can prove them without being graphic and without being over the top. Because what actually wound up happening is when you generate all these different things and you get on the stand and you cry, but you can't produce tears, it tells the jury that you're an actress and you're acting. Was she acting? I have no idea. I'm not a body language expert. I'm not a truth-telling expert. I'm not a human lie detector. But I can tell you this much. I didn't believe a word she said. And I think the jury didn't believe too much of what she said either. Except maybe the part about not spilling the wine. I don't know. Because obviously they gave her some money for that. Whether or not she ultimately winds up with that money will be a question for down the road. But yes. So part of the problem was Miss Heard and how she went after testifying, and all of her descriptions were over the top. She added all of this detail, and I can assure you that generally speaking, when people are being harmed, the thing that they are not looking at is the floor and the carpet and whether it's dirty or not. What they're looking for is an exit and a way to get out of there. I think for the most part, Ms. Heard's testimony was just over the top, and that's what doomed her. Now, the other thing that I have to say is the lawyers did a very, very bad job of preparing her for cross-examination. The purpose of going through cross-examination is to get to the end of it. They're going to have questions, and they're going to be a lot of yes or no questions, and you answer them yes or no. And you trust your lawyers to come back afterwards and say, you were asked about this. Did you want to say more about that? Yes, I did. What did you want to say? And then you explain it. Unfortunately, when it was her time to be redirected at the end of that cross-examination, her lawyer couldn't think of a way not to ask something that wasn't a leading question. So, in some respects, Amber Heard's lawyers may have failed her in that regard, although I don't judge them too harshly, because I think it must have been very difficult for them to work with a headstrong client, and I think she was pretty headstrong. I don't think she was coachable with respect to how to undergo cross-examination, and as a result of that, although I'm sure they worked with her, and I'm sure they tried very hard to get her ready for that, she just did a terrible job on cross-examination. And Camille Vasquez, God bless her, she did a fabulous job. And if they don't promote her to partner, she'll be running her own firm in a year. So hopefully Brown Rudnick will make the right call on that one. So that's my take on whether or not Amber Heard could have won the trial. My belief is she probably could have if it had been handled differently, if she'd showed a little bit of humility, if she hadn't come on like she wanted to drive a stake through Johnny Depp's heart, she might have had a better chance. If she'd come in and say she never had any intent to impugn his reputation, she didn't really mean to cast stones on him. She understands how it could be taken that way, but that wasn't her intent. But I think it was very clear at the end of the day that that was exactly her intent. And I think that's sort of what did her in. So, again, those are my takes, my thoughts on these issues and this case. If you have any comments, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel and tap on the notification bell so you'll be notified anytime we release a video. Like, share, subscribe. Really appreciate all of that. Thank you very much for watching and have a terrific day.